Alrighty, so we are recording right now, so that's fantastic. And I think we can get started. So the idea of this seminar webinar started with our conversation, and to be honest with you, every single time I feel like I can provide the value to our clients. I want to make sure that we can do it. Hello, I can see that somebody's joining us as well, so that's fantastic. So today we'll be talking as, and I mean the idea of this conversation came up with our initial meeting. So when you mentioned that you do a lot of tenant landlord type of litigations and relationships, I thought that, you know what, it's much better to have a conversation with you right now than for the people to get in trouble and then contacting you, because I feel like a big part of your job and my job is educating people. So that's precisely what we're going to be doing today. But before we get started, can you tell us a little bit more about yourself? What kind of law do you practice? Where do you practice it, and so on and so forth?
Sure. So I practice mainly landlord tenant law and family law.
Mm-hmm.
I also
Okay.
practice general litigation, sometimes personal injury cases, and patent law. So
Mm-hmm.
um, for if we're doing civil cases, I can pretty much help anyone anywhere in California, and
Mm-hmm.
that's what I do because I have a client who is in Orange County now. I have some client who is in who is in San Joaquin County, and I will probably soon have clients in Placer County too. So yeah, I'm not even counting people in Alameda and San Francisco and generally in
Mm-hmm.
the area. So
And when you say civil law, what exactly, what kind of cases fall under the civil law?
well, it will be pretty much everything from when people are divorcing,
Mm-hmm.
or when so it's essentially when someone has done something wrong to somebody else, and that somebody else wants to sue that someone.
Mm-hmm.
And in this case, what happens is that people would basically be so the state has nothing to do with that.
Okay.
So it's not criminal law where the state would prosecute someone for violating, the penal code, California penal code, or whatever in the whatever happens in the federal court. But this is just the disputes, the wrongs between private individuals or or entities. Sometimes there could be government entities too, but in this case they act as private entities.
Got it, got it, got it. And as far as the tenant landlord direction, how did you get into this field of law? Because it's a very, very specific, and I feel like especially here in California, I mean it's so well known, and we all hear about those cases of that get a lot of publicity of people living in somebody's property for 500 something days for free. How did you get into that specific kind of line? What attracts you in it?
Yeah, so it's a very good question. So I started volunteering. So when I was first admitted to the state bar, which was more than 8 years ago, I started
Mhm.
volunteering, and through my volunteering for low income landlords, I sort of learned the basics of this law, and then
Low income landlords. It's a very interesting direction, because you would usually hear people volunteering and protecting tenants, but there is such a thing as a low income landlords.
Yes, and because it happens more often than we think. Because what
Hmm.
happens sometimes is that people are basically people are, for example, inheriting a property
Hmm.
from someone, or they're buying it for and spending all their money and hoping to get some rental income and live
Yeah.
off that income. And sometimes they have to deal with not very good tenants, and the house is not in the best state of repair, and
Hmm.
and that's where the problems start to accumulate. And so, yes, there exist low-income landlords as well as low-income tenants.
Yeah, no, it's a very interesting argument, and the reason I brought it up is because a lot of the time public opinion is that the landlord is that evil person that doesn't raises rent all the time, and being a slumlord or whatever you want to call it, not taking care of the property in a proper manner. So a lot of the time the narrative, especially here in such a liberal state as California, a lot of the time narrative is that the tenant is the poor little thing that that doesn't have enough money to pay rent, and the landlord is that evil institutional type of guy that wants to extract as much money as he or she can. But a lot of the time you're actually right, and in my practice I come across cases like that all the time, where people just have possibility to purchase another property, rent it out, but then with somebody that wants to move in and doesn't want to pay, that creates a huge problem, because this is all that the person has, all of the assets that they have.
Yeah, you're absolutely right. There are tenants from hell and there are landlords from hell, and I mean it just depends on the type of person they are, and there are slumlords. I've seen slumlords. I've seen really really bad tenants who are, by the way, harassing other tenants. But fortunately it doesn't happen too often, but it happens often enough when when it requires intervention by an attorney.
Well, so let's get into it. I think this is a good segue for us to actually dive into the questions that I have. And forgive me in advance, a lot of those questions would be sort of a simple nature questions. Somebody would qualify them as a stupid questions, but a lot of the time I feel like people are afraid, ashamed to ask those questions because they think that they should know the answers to those questions even before they purchase the property or become the landlord. But I'm going to ask you those questions nonetheless, and hopefully we can get to the bottom of the principles that stand behind landlord and tenant relationships. Because a lot of the things that we'll be talking about will be specific not just to Los Angeles, but to California as well. We're going to start with an issue of rent control. So what is rent control? How do you define that?
So right now, pretty much the whole state of California is under rent control regime, and that since the year 2020. But before that, there were certain jurisdictions, certain cities where you cannot raise rent by more than a certain amount. And that's what meant rent control. Right now in the state of California, unless your house is exempt from rent control, you also cannot raise your rent arbitrarily. So,
Okay. And
go ahead.
on. Sorry. Yeah, no, go on.
And so basically what happened there is that in these rent control jurisdictions, which I would consider traditional jurisdictions, the allowable rent increases and the number of them is going up. For example, like recently, a city of Concord adopted the local ordinance that it will become the rent controlled and just cause, we'll talk probably about it later, just cause eviction jurisdiction. But it just allows a landlord to raise rent only by, let's say, 3 or 4% per year, whereby overall in the state, and again, unless this house is exempt from rent control, so you can raise, or a landlord can raise the rent by up to 10%. It basically 5% plus the inflation index for that county. So this is how it works.
Okay, so if I understand correctly, rent control is sort of statewide overbearing type of law, but then there's also rent control that's being implemented on the municipality level. Do you know how does this work in the greater Los Angeles area in general? Los Angeles as a city, Los Angeles County, possibly?
My understanding that it only this rent control regime, not the statewide but citywide, it applies only to the city. And
Mhm.
in Los Angeles, it's Los Angeles County. There are several cities which have rent control, and so this is Los Angeles. So sort of the actual city, and it has to be, the house has to be within the actual city limit. Then I believe there is Santa Monica. There are several other cities, smaller cities, sort of satellite cities, that have this rent control, the citywide rent control. The same, for example, happens in the Bay Area, San Francisco Bay Area,
Mhm.
where there is rent control, for example, in the San Francisco itself, but San Francisco itself is pretty much the same as the San Francisco County, so it's like county-wide, unless you consider federal Long
Mhm.
Island inhabited by great white sharks and seals. Those are not under rent control. But in San Francisco, there is a rent control. There is rent control, for example, in Berkeley, in Oakland. So those are the I would say three most extensive rent control jurisdictions in the Bay Area, and probably the next one is Los Angeles. So it's not in the Bay Area, but it's also very overbearing. I would put it this
Mhm.
way. It's also very extensive. Again, it depends. For the landlords, it's probably overbearing. For the tenants, it's probably good,
Of course.
mainly good. But it's debatable though. Yeah.
Of course. What's your view, since we're already touching rent control? What is your general view on rent control as a thing statewide?
Well, I'm not a politician, so I just work within the confines of the law, state, federal, and local law. And so there are advantages and there are some good things about rent control, but there are also bad things about rent control. And so I can give you an example, like, I, so for example, with the state rent control,
Mhm.
I mean, it's all good and it's great intentions, but what happened is I had a client who was renting his house and wasn't raising rent for a very long
Mhm.
period of time. And then, when rent control was adopted, he still wasn't renting, but then he kind of realized, oh, they're paying probably half the price of the market value, and this
Mhm.
is fair. And so he tried to raise rent. He wasn't aware of rent control, and then he got a letter from legal aid. And as a
Mhm.
result, he's like, "What should I do?" Well, I mean, he can either raise it by this very little amount, which is
Yeah.
10% right now, or he can just evict the tenant and put in and just let his daughter live in this apartment, because his daughter is paying significantly more in rent. She's renting an apartment somewhere and she's paying
Wow.
significantly more rent. And so it's like, good intentions can sometimes pave the road to hell. And so that
Yeah.
is, that is one of the examples where, the state law, and I'm pretty sure it's not the only example, but it's something from my practice. This is something.
Interesting.
So yeah.
Interesting. So you mentioned certain properties being exempt from rent control in general. When you talk about exemptions to rent control, are those geographic exemptions? Are those exemptions that are due to a certain age of the property, location of the property? What properties are usually exempt from rent control law?
Well, it really depends on the specific jurisdiction, and actually very fluid. Whatever was true like 2 years ago, for example, for San Francisco or Oakland, is no longer true today. And so you have to check the specific ordinance. But in generally, and right now with the state rent control exemptions, it's becoming increasingly complicated. I mean, it takes, I know how to navigate that because I am an attorney and I specialize in that area. But a lot of landlords, as for example, my client, they just don't know how to navigate and they run into issues. So, for example, the state law the state law exempts all buildings which were built, in the past 15 years.
Hmm.
These are exempt from the state rent control and just cause evictions. So the landlord can raise rent, and it's pretty much clear why they're doing it. Now, the most of the local ordinances, they exempt properties built after the ordinance was adopted,
Hmm.
which is also quite strange because but then they would also fall. So there is basically, for example, like, and again, don't hold me to it, so that might no longer be true. So for
Of course.
example, certain buildings were built, for example, so the rent control, for example, was adopted in 1969. So
Hmm.
it only applies to the buildings which were built before 1969.
Right.
But the newer buildings, technically speaking, it shouldn't apply. But right now, with the state rent control, those buildings are also covered but under the state law. And
Hmm.
if I haven't confused you, tremendously, I can continue. But I think it's
Continue
confusing.
confusing me. No, you're actually not confusing me. But to simplify it for a very practical purposes, when the person purchases a property, how does that investor, individual, institutional, doesn't matter, find out if the property is located in a rent control area or not? Is there sort of a resource where the person can go and see?
Not. I'm not aware of any sort of unified resource where it would tell you whether it's
Hmm.
under rent control or not. So most likely that person should analyze where this property is located. So that's what I would start with. I would start with, for example, is if this property is a multi-apartment unit within the greatest city of Los Angeles, it's probably under rent control. If it's a single home in, let's say, Los Angeles, it's probably not single family home. So it's probably not under rent control. Although, let me take it back, and maybe it's not, maybe it is now. But at least before, certain jurisdictions had exceptions for example, like single family homes. Um, but again, these exemptions, they would apply. There was a recent case where the landlord was renting a house, a single family house, for,
Hmm.
say, 3 or 4 people.
Hmm.
And the argument was made that this is under rent control, even though it's a single family home and it's zoned and occupied and it's supposed to be occupied by a single family, but it was occupied, it was divided by among several
Wow.
roommates or people living there. It was rented separately by the
So it
landlord.
was it was treated as it was a multifamily property according to the letter of law, even though that zoning and the use were, well, the use, I believe it could be argued that the use was the multifamily. That's
Yeah,
very interesting. It's very interesting. Okay.
and it
So in
was by judicial, and to make things worse, it was
uh-huh.
by decision, by the judicial decision, by the judge
Oh.
and by the court of appeal. And so when that investor probably would have bought this home, he would have, even the attorney wouldn't be able to help him because no one knew that it was under rent control before the judge made his pronouncement.
Wow. Um, just a quick remark. I think in the city of Los Angeles, there is a resource called ZIMAS, where you could check the zoning and all of the permits and legislations as it pertains to a specific piece of property. And that would be a good frame of reference to start people's search as far as checking out whether or not the property is located within the rent control area or not. I think rent or stabilization ordinance, RSO, that would be the official name that's being used here in the city of Los Angeles. So, and ZIMAS being the resource that I think comes from the city of Los Angeles. So that could be a really good source for people to go and check out. But let's get a little bit more practical. So rent control, we kind of understand what it is, but what does rent control mean for the tenants, and what does it mean for the landlords? So let's split this question for the two parts. So for the landlords, my understanding is that it limits the landlord's ability to raise rent on the annualized basis. Is that correct?
Yes.
And is there anything else that entitles being under rent control for the landlord specifically, and then for the tenant?
So there is another concept called just cause evictions, and so normally rent control comes not just as rent control, but also under the just cause eviction. So the properties, and sometimes the properties that are covered by rent control, they're not covered by just cause eviction. Sometimes they are. And so, but very often it's the same thing, because this very often the same properties are under both rent control and just cause eviction.
And I promise I'm not texting my girlfriends or anybody else. I'm just making a note to come back to specifically just cause eviction, because we'll talk about eviction in just a minute. Okay, so that's the landlord side of things. As far as the tenant side of things, it's pretty much entitles the same thing, just the opposite side of that medal.
It gives the tenants the ability to, sort of predictability in terms of how much the rent would be raised. And if the tenants live in the property for a long period of time, it almost becomes their estate, because they are paying significantly less than the market value, significantly less. And that's sort of, it may have certain appeal for the landlord, because it kind of promotes the stability. The tenants are not like moving every year in and out of the apartment, but also it entails that the landlord cannot collect, is missing on a lot of rent. And so, so again, there are two issues, and it's not. I cannot tell which one is good, which one is bad, and so it's just it's the law, so we can't do anything about it.
Of course, but in my practice, because I work a lot with Russian speaking clientele, and in my practice, it is a very difficult topic sometimes, simply because, just as you say, there's two sides to this coin, and it allows people to stay in a property for much less than market value for many years, because it's very difficult to evict people that live in the properties that fall under rent control, and the amount of money that they're paying is significantly less. But the other side of this coin is that I'll give you an example from my practice. For instance, when I work with people, when I would have a casual conversation with somebody who's been living under rent control for 20 years, they're accustomed to paying almost nothing for rent, and they might want to buy something, but what they are accustomed to paying on the average basis, and what they would need to pay in order to get into the housing market nowadays, is just completely, it's not comparable. It's not within the same realm of possibilities. And there is a lot of people that have gotten stuck under rent control for the last 20, 30, 40 years, especially the previous waves of immigration that were able to lock those properties in great neighborhoods, such as West Hollywood, for example, being one of them, one of those neighborhoods. And it's very difficult to tell those people that there's just nothing that they can afford, with the budgets that they have right now, and there's nothing that they will ever be able to afford because they're accustomed to paying so little under rent control. So I'm 100% with you.
Yeah,
There's two
yeah,
sides to this coin.
yeah, you're absolutely right. Yes, you're absolutely right.
So as far as not being under rent control, let's talk about well, let's continue the rent control at this point in time. But so you mentioned that there's a certain limits to how much the landlord can raise rent being under rent control. So at this point in time, my understanding is that it's a 5% plus another percentage based on how the economy is doing. Is that kind of how it's being calculated?
It's on the state level. It's not on the city level. So, for example, for Los Angeles, it's probably significantly less than that. Again, I don't remember the exact numbers, but it's probably something along like 3% or something along these lines. So
On top of 5%.
no. It's just 3%, and that's it.
It's just 3%.
Yes, it's just 3%, and that's it. So they could also sometimes, the landlords, and again in some jurisdictions, they can so-called bank the rent, bank the rent. For example, cannot, for example, can not raise the rent for 1 year and then raise it, for example, not by 3%, by, let's say, by 6%. So bank these rent increases, and that's often what happened. But normally the landlords, they're pretty consistent because they're losing their money, and you cannot bank it like forever. And so if they stop raising rent, it means they can only raise like 3% when the market rate, for example, will go up 20%, and so they are losing a lot of money. And right now you can see that people are living, at least lucky people are living, paying, let's say, 1/3 of the market rate, and that causes a lot of frictions, honestly saying.
As far as a couple of questions, if the property is not under rent control, is there any limits to how much can the landlord could raise the rent in annualized basis? Is there any limits to that?
Theoretically, yes. So there are other, although they're not as easy to. So theoretically, the landlord can. Well, it depends on. Again, the answer is it depends. So let's say we are under the emergency proclamation due to fire, flood, whatever, alien invasion, and then something along these lines. So if that happens, then that limits the ability of the landlord to raise rent by more than 10%, usually.
And in
Now,
Los Angeles, just to give you an example, we've had that happen, I believe, with the Woolsey fire, with the fires that hit some of our very, very expensive and exclusive neighborhoods like Malibu, for example, where people were going through the hardship, and a lot of landlords just spiked the prices. So the city had to put the stop on it. So I believe something very similar to what you're saying was implemented in order to keep the rent raises under the wraps.
Yeah. Plus, there could be an argument raised, by an attorney usually, that if the landlord is raising rent too much, that it's for the purpose of evicting the tenant, getting rid of the tenant, and so. And it could be, the landlord could be sued if he is, not careful. And
Understood.
so that basically the idea is that the rent is being raised to get rid of tenant rather than evicting the tenant, sort of forcing the tenant out. But again, that opens the landlord to potential liabilities, and it's in my opinion, for the landlord, it's a very dangerous thing to do, regardless of rent control or whatever emergency proclamations or anything like that.
Got it. Thank you very much. And I suppose the last question under rent rises. under rent control. So the landlord is very much limited to a certain amount of a percentage as far as the how much can he or she can raise rent for the same tenant. But if, for example, one tenant moves out of an apartment or a condominium, let's just use apartments as an example. If the tenant moves out from the apartment and the apartment is under rent control, can the landlord raise the rent for more than 3%, or is he or she still limited to that same percentage under rent control law?
This is a good, yeah, this is a good question, and the answer is affirmative. Yes, the landlord can then raise the rent to whatever amount he or she wants to raise it. And that brings us to that probably brings us to the issue that,
Yes.
how the tenant left, whether the tenant left on his or her own, or whether he was evicted, or whether there's something unseemly in the way the tenant left. And so
Precisely. Yeah, that's actually exactly my next question. That's the next direction that I wanted to take, and I want to talk about eviction. So what is eviction? How do you define that?
yeah, so about, I would say, 150 years, more than 150 years, in California, California realized that people are attached to their homes. And you can just barge in. For example, a family lives in the house, and a landlord cannot, like it's shown in the mafia films or whatever, cannot just barge in and under the start threatening them and evict them by force. So this is absolutely prohibited in California. So there is an expedited process for eviction, and it's called unlawful detainer. So if there is a tenant who does something wrong, for example, the tenant doesn't pay rent, or the tenant smokes, or the tenant does some kind of nuisance or commits crimes, for example, like makes meth, is involved in prostitution, or actually causes some kind of criminal activity, would be a reason to evict that tenant.
Mhm.
So even pretty much everywhere, but there has to be sort of a legal process, and that process starts with giving a tenant a notice. So
Mhm.
it would be either 3-day notice to pay or quit, um, you know, 3-day notice to perform covenant to quit, or 3-day notice to quit sometimes, because if the tenant is committing really bad nuisance, then he can just the landlord can just give them a notice, just quit in 3 days. So, or if the tenant refuses to pay rent, so, whatever you do, and that, by the way, will be true in any jurisdiction, even if it's
Mhm.
rent controlled, non-rent controlled, just cause eviction, not just cause eviction. So those are the reasons to evict a tenant. There are other reasons, but they're all enumerated. For example, like if the landlord wants to move into that apartment himself, or he wants, for example, to move in one of his or her immediate relatives, or something
Mhm.
like this. So that would be the reason to evict the tenant. So there are all the other reasons to evict the tenant, but those are
That
these.
basically, in generalities, if the tenant is breaking the contract, if the tenant is breaching the contract, which is a lease, so there is numerous reasons to evict the tenant. And what kind of evictions are there? You mentioned there's a just cause eviction. There's probably some other kinds of evictions
Yeah.
that are performed in the state of California.
Yes. So right now, the whole state of California is under the rent control. The same applies to the just cause eviction. So
Mhm.
unless again the house or the apartment is exempt from just cause evictions, then the landlord cannot evict the tenant unless the tenant does something wrong or for one of the enumerated reasons. And again, enumerated reasons, for example, maybe like the landlord wants to move in himself, wants to like completely remove the building from the market, or things like of that nature. So so it just before, for example, you live in a property, and at any time the landlord wants to evict the tenant, he can just give a 30 or 60-day notice, and after that the tenant should be out, or the landlord can sue the tenant, and that would be an expedited proceeding. So like for example, it's called UD, unlawful detainer, and again, it starts with the notice, and then you go to court, and then you give this, you serve the tenant with the summons and complaint, and then after that, it's expedited because the tenant only has 5 days to respond, and whereby, for example, in regular civil cases, it's 30 days. And so everything moves in this expedited, timeline, and normally they're done in like a couple of months. Supposedly by law it should be like 20 days, but it probably done on average, I would say, in a couple of months. And then then the landlord can get a judgment, providing that he has done everything right, and then the tenant has to leave. He will be evicted by the sheriff. Again, not by the landlord. The sheriff has to come and physically evict the tenant from the apartment.
So there's a certain procedure to removing the tenant. So you briefly mentioned just cause eviction. You mentioned constructive eviction. Can we talk a little bit closer about just cause eviction? What is it? When is it being used? And how is it used?
You mean just cause eviction or constructive eviction?
Let's start with the just cause eviction.
Yeah, so just cause eviction is when you have this limitation that you can only evict for these enumerated cases. They're split into when tenant is at fault and when tenant is not at fault. So when tenant is at fault, meaning it's like, again, non-payment of rent, nuisance,
the breach of contract, whatever way it occurred.
Lease violations, various lease violations. When tenant is not at fault, it could be because they want to like renovate the building, they want to move relatives in, they want to, for example, just stop renting at all. Just the landlord wants to exit the market. The landlord no longer wants to be a landlord, for example, for this particular building. And other cases, for example, like if it's an unpermitted unit, the inspector may come and say, well, it's an unpermitted unit, you have to evict your tenant and you have to bring it to the building code, up to the building code.
Okay. How about constructive eviction? What is constructive eviction and how does it work?
Yeah, so constructive eviction is a little bit different. It means that someone is so the landlord usually creates conditions for the tenant that the tenant can no longer live there. For example, I mean, the most outrageous cases, I'm not making it up. The tenant could shut off hot water, stop the heater, start banging on the door at night, or create some like insurmountable problems for the tenant, where the tenant decided, I mean, look, it's not worth it, I'll just leave and to hell with it. So this is constructive eviction. So when the tenant is forced to leave the property, supposed on his own volition, but because of the circumstances created by the landlord. And I have to say, it's not advisable for the landlord to do things like that, because recently, for example, there was The landlords in California, a guy whom I know, an attorney, he got probably like 2.4 million verdict against the landlord for constructive eviction. And
Oh wow.
yes,
So
and
so the tenant, let me understand that correctly. So the tenant was basically forced out of property by somewhat of an aggressive behavior um by the landlord. So the tenant ended up suing the landlord for
yes,
what's called constructive eviction, basically for forcing the tenant out of the property, and the tenant got a settlement of over $2 million.
yeah,
That's
and
expensive to force your tenant out of the
yeah,
property.
it could be very expensive. And where this sum comes in is because in Los Angeles, as far as I remember, also in several other jurisdictions like San Francisco, Los Angeles, I think, or Oakland and Berkeley, maybe some
Mhm.
other jurisdictions in the South, near Los Angeles. So if so the idea is you calculate the damages, and the damages are
Mhm.
calculated. For example, like I lived in an apartment and I was paying $1,000 per month. Now
Mhm.
I had to leave, and now I am paying $2,000 a month. So
Mhm.
my damages are now $1,000 a month, and that for the number of years that I intended to live, that I can testify. Like, for example, if I'm 40, maybe I will live there for another 30 years. And so you
Wow.
multiply that, and that's going to be your damages. Now but that's just the beginning. Now that would add emotional distress. That would add certain other fines, which are compulsory. Um,
Mhm.
that sometimes can add, certain of these causes of action. They also have the attorney's fees for the tenant. And
Mhm.
then on top of it, well, it's not yet on top of it. And so then it multiplies sometimes by three.
Why by three? And
Um,
why does it multiply to begin with?
yes, because it's by, so you calculate the actual damages, including, the damages due to eviction, the emotional distress, other damages, and then that is multiplied by three. And that would be a judgment. But on top of it, if the landlord was acting in a particularly egregious manner, uh,
Mhm.
there will be punitive damages. So,
Okay.
which could also be like, normally I would say they're around, twice as much. Once, so it's basically, then you
Wow.
multiply it by, you add another number to that, another number to that amount, and that's how you actually can come up with the very large number for of damages for constructive eviction. And so it is particularly dangerous for the landlord to constructively evict people who who lived there for a long time, and then under this regime, so where they paid not a lot of money, and then they moved out. For example, the landlord did something, to force them to move out. And if
Mhm.
that happens, then the tenants can actually get enough money to buy a new home, and not
That's a lot of multipliers. That's a
yes,
lot of
and that's
multipliers that really.
exactly, and that's a lot of multipliers. Yes, I agree with you.
Yeah. As far as the tenant side of it, when the tenant receives a notice, either notice to pay or quit, or notice to stop certain actions that he or she is performing, what does the tenant need to do in order to protect him or herself? I understand that the first part, and in ideal world, the tenant would just stop doing what the tenant is not supposed to be doing and continue doing what the tenant is supposed to be doing. Either that's the payment that needs to be made, or certain action that the tenant will stop. But I'm pretty sure it gets much more convoluted in your world, and we're all human, and we communicate with human, and we work with people. So what is it that the tenant need to do when the tenant receives one of those notices, and the eviction process is getting started?
Yeah, so I actually helped a few tenants with that. So at the stage where they were receiving just this first notice, and if I represent tenants, I actually prefer to deal with them when before or around the time when they receive this first notice. Um,
So they
so
need to contact you as early as possible. That
yes.
allows you to analyze the situation, and even if they were to continue living in a property, at least they would have the rights available to them. They would know about them.
Yes, and so yeah, you're absolutely right. It's better to, because once the eviction will be filed against them, the eviction lawsuit
Hmm.
filed against them, unlawful detainer, then they only have 5 days to reply, and it's an extremely tight deadline. And so for any attorney, and so because attorneys are busy and they have other deadlines, and now this one comes in, and so it's sometimes for an attorney it's almost impossible to comply with this kind of deadline. And so it's better if the attorney kind of knows the situation ahead of time, when this notice, especially if this notice was given, or even at the very beginning when the problem starts accumulating. But in this case, what I did, so I had actually several cases like that. This in
Hmm.
one cases, the guys just subleased it. Well, not subleased, but they let one guy. So they were driving. They went somewhere and they asked the guy to sort of house sit for them. And
Hmm.
at the same time, they got this 3-day notice to perform a quit, because the landlord was alleging that the guy was, they were subleasing in violation of the lease. And so what I advise them immediately is to ask that person to leave right away. Just
Hmm.
pack his stuff and leave, and then inform the landlord by all means. And I ask them, send them a letter, send them a FedEx, call them, email them that you complied.
Hmm.
And it's very important because, then the landlord within these 3 days, because the landlord then, even if he or she files the eviction lawsuit, he cannot claim that it was, that the tenant did not comply, because the tenant
Hmm.
informed the landlord, even though it's not required supposedly to inform the landlord. But that's the best course of action, to inform the landlord that you complied. But I would say in 90% of cases it's about the pay rent or quit. And so in this case, I am advising the tenants to immediately pay the due rent, whatever is indicated in that notice.
Makes sense. So let's briefly go and talk about some of the terms that are being used a lot of the times, but might not be fully or properly understood by both landlords and tenants. So habitability. So what are the standards of habitability? What is it? How is it used in a landlord-tenant relationships, or maybe abused, as people do sometimes?
Well, so habitability generally means that it only applies to residential tenancies, first of all. So it does not apply
Hmm.
does not apply to commercial tenancies. So commercial tenancies do not have to be habitable, but residential tenancies, they have to be habitable by law. And what it
Hmm.
means is that they have to comply with certain building code requirements, both on the local level and on the state level.
Hmm.
So, one of the examples, like insulation, the house or the apartment needs to be insulated from the elements. Like, for example, there shouldn't be any holes in the walls through which the rats can go in, or but that's, by the way, another reason. So if there is infestation by bugs, rats, whatever, other types of vermin, the house also
Mhm.
is not habitable. There
Mhm.
needs to be, for example, on the state level, there has to be the heating in the house, working heater.
Mhm.
There needs to be mail receptacle. There needs to be a deadbolt on the deadbolt on the door. The windows have to comply with certain minimal standards because they shouldn't
Mhm.
be, you know, there shouldn't be any holes in the windows. There shouldn't be any mold, for example, in the apartment, and that
Mhm.
and bed bugs, so which would be infestation. And so there are a couple of other requirements, but they're not as kind of substantial. I think garbage receptacle would be there. But as example of local regulations, for example, Los Angeles is now considering forcing landlords to provide not just heating but AC, air conditioning.
Mhm.
So the
Mhm.
units would have to be habitable. The units would have to be air conditioned. And so, and I would say that this habitability requirement is very serious because, you know, if the landlord is collecting rent for the unit which is not habitable, um, you can the tenant can then sue the landlord and get the rent
Mhm.
back. Even, and I'm not sure if there is even statute of limitations. So on that. So, but the tenant will definitely require, for example, if the tenant lived there for 10 years and something was missing, and he or she was telling landlord, okay, for example, like the heating isn't working in my apartment.
Mhm.
Even if the tenant does not heat it up, doesn't need it, it's still not habitable, and the tenant can still get all rent back.
Interesting.
Yeah.
Interesting. So the next term that would like to discuss damages. Can you talk about damages?
Yes. So, well, okay, damages is we've already talked about damages, and so basically, there are damages for constructive evictions.
Mhm.
Are you talking about legal damages or damages to the apartment?
Well, let's legal damages we already discussed.
Yeah.
So
Okay.
let's talk about damaging the property, for example, in a case where the tenant is moving out and there's a certain damage that's being conducted to the property. So what are the rights that the landlord has to deal with this particular circumstance?
Um. Okay. So the landlord normally has security deposits, which can, at least to some extent, cover the damages.
What
The
if it doesn't? What if it's just not
um,
enough to cover the damages that the tenant caused?
So theoretically, the landlord should document the damage done to the apartment really well and sue the tenant who moved out in the small claims court. Uh,
Hmm.
the landlord has to, by law, has to inform the tenant about the status of security deposit within 20 to it's either 20 or 21 days after the tenant moved out, if the tenant left the forwarding address. And so the landlord has to give this deposit back, except whatever was used to cover the damages. But if that wasn't enough, the only legal recourse for the landlord is to sue the tenant, for example, in small claims court. Um,
Interesting.
I have to
Interesting.
tell you that as a practical remedy, uh,
Hmm.
I have seen a lot of cases where the judges would not award a very substantial, even when the damages were documented really well.
Hmm.
The judges were not awarding the whole amount of damages. And so,
Hmm.
on a practical level, at least in especially even in Orange County, that happened to someone I knew, and I was helping him to document and to document the damage. That person lived in Orange County. His tenant left. He damaged the apartment by a significant amount. The landlord had to spend a lot of money fixing the apartment, and then
Mhm.
only like maybe one third of it was reimbursed.
Well, I guess it speaks to how tenant friendly our state is in general. But next question. So you touched briefly on a security deposit. So let's build up on that a little bit.
Mhm.
Um, what are the what kind of disputes are you seeing as it pertains to security deposit, and how precisely is there a mechanism to determine how much of a security deposit needs to be returned, and what happens if, for example, um, everything is well documented? Here in California, we use MIMO form, move in, move out inspection. So if, for example, the property has not been damaged, if the property has been left in precisely the same condition as during the move-in time, and the landlord still doesn't want to return the security deposit, what would be the actions of the tenant in this case?
Well, I have to tell you, I wouldn't want to be that landlord. So because it's extremely dangerous. So the landlord has to return the security deposit within, minus the whatever damages they fixed within 21 days, and
Mhm.
has if whatever was expended, there must be the landlord must attach, for example, the receipts for whatever work was done. Now, very often what happened is that, and by the way, it happened to me also. So when I
Mhm.
my house, I moved out of the apartment, and the landlord, probably not knowing that I'm an attorney, sent me the letter with,
Rookie mistake.
yes, asking for $300 because of cleaning, and we cleaned it really well. And I wrote the landlord a really polite letter of what's going to happen to him. And the next question was, can I just do it tomorrow and not today? And so, can I, how do you want money? By check, by whatever,
Mhm.
Zelle, anything. So, um, this would be so again, the if the landlord unjustifiably and especially maliciously withholds the portion of security deposit, the tenant can go to small claims court and sue, and not will only that tenant get that security deposit, the whatever remainder, it will be in triplicates. It will be three times that security deposit, could be three times. So
Really?
yes, depending on what the judge will decide. So it could be three times of whatever part was withheld. And this is very dangerous because it happens all over when the landlords, and maybe not like they're just simply uneducated, and they're
Mhm.
simply they think, oh well, I'll just charge $300 for cleaning, and after the tenant, even though
Yeah.
the apartment was fairly clean. I mean, it doesn't have to be like sparkling shine after that. It's part of the business expenses for the landlord, for example, to repaint the walls
Yeah.
and do things like that. Somewhere I read that if the tenant is let's say less than 1 year, then the landlord can do it, but like repaint the walls or. But I would strongly advise the landlord not to do it. So one reason is this treble damages, and the other reason, the tenant may remember that, for example, oh, you know what, there was mold in my apartment and I started coughing. And then I went to the doctor, and I lost my sleep.
Mm.
And now we're not talking about 300 bucks. We're talking about $300,000. And yeah. And so it's just, it would be, in my opinion, completely unwise, short of saying absolutely idiotic, on the part of the landlord to withhold the security deposit. That's unless there is like really good reason for that.
Mhm.
So,
And my question is, who does, in very practical example, who does the burden of proof fall to? If, for example, landlord thinks they can keep the deposit because they need to repair place, the tenant thinks that they should be receiving the deposit because they haven't done anything bad to the place, and nobody has anything documented. Because a lot of the time when the brokers are not involved, and even when the brokers are involved, you advise people on sign in, move out, they just neglect it. You cannot make people sign those documents because it is their right. It is there to protect them in the end of the day, but some people just neglect it. They don't want to deal with it. So let's imagine the scenario where obviously a person moves out of an apartment. The security deposit is something that the landlord keeps. Nobody has a paper trail, so nobody has anything to show that the property was in this condition before the tenant moved in, and property is in this condition after tenant moved out. So who has the burden of proof in this situation? If the tenant wants to return their deposit, landlord doesn't want to do it. Who needs to prove that they're right?
it's a very good question. I think, well, so first of all, normally the plaintiff, meaning the person who sues, who filed the lawsuit, has a burden of proof. But in this case, in this particular case, the landlord must prove that the deposit was withheld, for a good reason. If the landlord does not have documentation, I would say he's done. So it's going to be really bad he's definitely going to lose. If the landlord has documentation, he has some fighting chance, although I wouldn't say that it's a sufficient significant chance, but he can do something about it, perhaps. But not much, honestly saying. Again, I'm talking from my practical experience, what happens and where. So also,
Understood.
maybe we haven't covered, but when if the landlord wants to have any chance of deducting something from the security deposit, what the landlord has to do, before the tenant moves out, the landlord has to give like 3 days notice or a couple of days before they move out. It's called a walk-in inspection. The tenant has the right to request that the landlord would come in and point to him or her which defects to fix.
So if the landlord doesn't do it, the tenant moves out, that's too little too late, so to speak.
Exactly, yes. That's pretty much fixes. Yeah, that's pretty much done. For example, I mean, obviously, if there is like a hole in the wall done with a
Right.
sledgehammer, obviously that's an obvious, that's not going to be a problem proving that, and the landlord takes a picture and then fixes it and shows it to the judge, that's going to be different. But for example, if the carpet isn't clean enough, or there is something like a nail in the wall, or which the landlord doesn't like, or if it's, let's say, more than a nail, maybe it's some kind of construction which was left, or something that was left. So in this case, the landlord should always do the move out inspection before the tenant moved out. As the tenant, for example, if he suspects there's something underneath the sofa, he can ask the tenant, okay, could you move the sofa? I just want to see the carpet, whether it's burned or not. And if the landlord does not tell that to the tenant, then these defects are waived.
Interesting. Okay, so next topic that you proposed was leases with attorneys' fees provisions.
Yeah.
What, can you talk a little bit more about that?
Yes. So lease, as every other contract in California, can include attorney's fees provisions, so that, for example, one party can say that if I am a winner, If I win, if we have a lawsuit, if I have a dispute about this contract and I win, I will get
Mhm.
these fees. But in California, it's not that easy because in case of such contracts, it's mutual. It automatically, by the force of law, it's automatically mutual. For example, the landlord puts in the contract that, if I have to evict you, you pay me attorney's fees. So
Mhm.
it's this is what, when I consult my landlords on how to do these leases, I always advise them not to include attorney's fees in there, or if they do, limit them, for example, to a couple of $1,000.
Mhm.
And that's because these provisions are mutual, even if it doesn't say that they're mutual. But overall, in all contracts in California, there is a mutuality of attorney's fees in the contracts. And basically, even if it says that only one side takes, can get his attorney's fees, the other side, if that side loses, the other side can also go and get attorney's fees automatically, and the judge will give it. Yeah, reasonable attorney's fees. So that's why I think, especially for the landlords, it's imprudent to put attorney's fees in the lease agreement, because if push comes to shove and they want to evict the tenants, eviction process is very it's very technical. If you make one little mistake, you're out, because it's fast. But because it's fast, and in exchange for its being fast, it's very unforgiving, and it's very technical, and it's very easy to make a mistake. And even an attorney can make a mistake, and I've seen that before. And there could be hundreds of places where you can make this mistake. And so in this case, the landlord who loses, if there is an attorney on the other side, the landlord not just loses, because then it's sort of fixable. They can refile. They made one little mistake, and it's like literally one little mistake.
Yeah.
um and because of this technicality, the case is thrown away. Then the tenant will come back and get, for example, like 20,000 in attorney's fees,
Mhm.
even though that attorney was a public interest attorney. And
Yeah.
so that's why it's actually a lot of attorneys, tenant attorneys, if they see that unlimited attorney's fees provision in the lease, they will take the case, because
Interesting.
yeah, they'll gladly take the case, because the landlord has the property, has the real property. They can always
Yeah.
put the lien on the property. They can always collect. Whereby the tenant, sometimes he just
Yeah.
disappears, and you can't collect from him or her.
Interesting. Interesting. Well, let's talk about some other controversial things, and some other things that actually made appearance in the news, like squatting, or what could be considered squatting. You mentioned some examples from your career, from your personal experience of working with the similar kind of cases. So let's define squatting, and what is it that could be done with it if you discover somebody squatting in your property.
Okay, so squatting, what it means is usually when let's say I have an apartment which I am not currently renting, or I have
Hmm.
a cabin somewhere like Tahoe, or let's say for you guys in LA, it's Mammoth Lake, somewhere
Hmm.
there. So you come there at certain point, and you find some people living that just basically living there. So the funniest part is what you do. What you do, you call the police, and the police comes, and they see that people, they didn't just break in, they are actually living there. So
Hmm.
in this case, the police will not do anything.
Gotta
So
love California.
yes.
I mean, this is something that drives people that come from Ukraine or Kazakhstan. Russia just nuts and crazy. They just can't comprehend it. It's absolutely incomprehensible for them.
Yeah, but I mean, on one hand, yes, you're right. But on the other hand, I mean, the cop may not necessarily know
Yeah,
whose side to take on. And so it's sort of more, it's more it could be more complicated. The cop, for
100%.
example, will believe, or the sheriff will believe, oh, I know that guy, and they're just squatters. He will, evict them or
Yeah,
arrest them for trespassing. And then it turns out that, they were actually had all the right, they had the right to live there. So the police, they're reluctant because then now the cop is liable. And
no,
so
it's understandable. But how do you deal if you deal with the circumstance you just described? You come to your second home and you see somebody happily probably living there. What do you do? What's your course of action there? You call the police, they come and they say, great, I can't really do anything. I don't know if they have a contract. So
yes.
what do you do?
So the first thing you need to do if you call the police, you need to, it's better if you know who these people are, to at least ascertain their identity, because you need to sue them.
Hmm.
And it's very hard. You need to sue someone. It's very hard to sue them under Jane and John, or John Doe or whatever. So it's better if you have their names, if you know who they are. And at
Hmm.
least the police can do, they can ask for the driver's license. They can tell who these people are. And so then you write down the names. And what you need to do, you need to give so-called 5-day notice.
Hmm.
So you put this notice on the door, or give it to them in person and say, just leave in 5 days. And it's a little bit more involved than that, because there is an exact text of what needs to be in this notice. But it's a 5-day notice, at least in case you came in and someone is like peacefully living in
Hmm.
your home. So, and then once these 5 days are up, you just go and sue them. And it's also an expedited process of suing.
Hmm.
It's
Well, the
very
California expedited is probably not different state
couple of months.
expedited. What's a California expedited?
Yeah, a couple of months. It's
Okay.
a couple of months. It's a couple of months. And, maybe in rural areas, they will be less inclined. And normally, once you sue them, they will be scared and they will just leave on their own, although they will damage your property and there is no recourse for them damaging the property. Uh, a lot of time, the attorneys, even the landlord attorneys, they make a mistake by treating them as tenants,
Hmm.
whereby they're not tenants. And as soon as they treat them as tenants, especially in the rent control jurisdiction, then all the protections for tenants attach.
Mm.
For example, like during the COVID, even if this happened during the COVID time, these protections were not applicable to protections applicable to tenants were not applicable to squatters.
Hmm.
They were only applicable, so you can still evict people for for squatting in your property, but you could not evict tenants. But they're not tenants; they become tenants if they do something for you. For example, if you let them in and you charge them
Yeah.
money, or you ask them to do something, as soon as it's there, then you need all these, formal causes. Sometimes
Hmm.
just cause eviction, sometimes, it's under rent control. And so even if they pay you like nothing, but as long as you like request payment from them, and as long as they paid for you, for example, they promise, oh, we're going to maintain the apartment, we're going to house it,
Hmm.
that will be considered tenants. And you got, it's like you just created the landlord tenant relationship. So cannot let, they'll just stay, they'll be much harder to evict them.
So my understanding is, if the situation like that happens, your best bet is to go to the lawyer right away, and
Yeah.
every single action you're going to be making, needs to be in accordance to his or her advice, simply because you can unexpectedly for yourself create a tenancy, and that will put them in a much stronger position compared to where they're at this point in time, where you just discovered them, you're pissed, but you still need to go according to the letter of the law. That
Yeah,
seems to be
exactly.
still the best case, huh?
Exactly. I mean, one maybe, and I'm not entirely sure if it's going to work. Someone suggested what else you can do. You can, for example, wait till all of them leave the apartment, and if you have keys, you can enter the apartment and then sort of squat on the squatter. So, but that is well, they wouldn't be able to evict you for sure, but they can come back again, and when you leave, and so that will, yes, that will start the whole chain of events, and
Yeah.
but technically speaking, I mean, it's possible, but I would be very worried about this kind of outcome. But again, before calling in a lawyer, you should definitely call the cops and at least ask them
Hmm.
to tell you who,
Identify them
yeah, who
as
is
a,
living there.
okay.
Yeah, exactly. Yeah.
Interesting. What are your stands on the situation that you might have seen or heard about that occurred over here in Los Angeles, in the neighborhood of Brentwood, where the woman was staying in a property for free for about 540 days? Are you familiar with that case? Have you heard of it?
Yes, I've read about it a little bit. Yes, it's yes, I read
What are your
about it.
stands on it?
Uh, I think, well, since she was staying there for longer than a year, she's no longer a squatter.
Hmm.
So she would have to be evicted as a tenant.
Hmm.
And because she originally started paying for that, or at least she paid. I think she, if I remember correctly, that case, that woman was actually paying in the beginning, so that
Yeah.
created the landlord the tenancy relationship, and she could not be evicted that easy.
How do you protect yourself in general against professional tenants? Is there anything that could be done other than just following the rules and regulations that fall under the jurisdiction of law?
Well, look, there should be some reasonable things to do. So if you have, so normally it happens if your house is uninhabitable. So if no one lives in the house for a long time.
Hmm.
And
Hmm.
so that happens usually, you go, if you, for example, go somewhere for a year to live abroad, what you can do, you can actually talk to your real estate professional like yourself, and just rent it out for that period of
Hmm.
time. Like for a year, for example, which will not create, if it's below the 1 year, it will not create the just cause eviction. It will not be under rent control and just cause eviction. For example, you can do that. You can ask you can go to someone who is a realtor, and just ask to manage the rental, and make sure that person collects rent in exchange for some kind of fee. So
Hmm.
that's one thing to do. The second thing to do is, for example, if you keep a cabin in the mountain, um, I mean, you probably keep like internet in there, so you can install a camera or several
Hmm.
cameras in there, and basically just periodically monitor what's going on. For example, like, if you see that someone is breaking in your apartment, you can call the cops, in that police department, and ask them to check on it, because if they catch that person in the moment they're breaking in, uh,
Hmm.
that's a criminal act. I mean, they're criminals. The police has every right to arrest them. But if
So
they're
as long as you can respond in a proper manner,
yeah,
in a timely manner rather,
yes,
you are increasing your chances not to have the long-term implications of
exactly,
squatters.
yes, exactly.
Okay.
Because once the cops realize that they just broke in, that they don't live there, They're trespassers. Well, they're at least trespassers, but they actually it's breaking and entering, or it's burglary, or it's one of these three penal code violations, and so they
Hmm.
can easily arrest them. It would be the misdemeanor, or it will be wobbler, or sort of something between misdemeanor and felony. So that is one thing to do. The other thing, if you have like a cabin in the mountains, you can ask your neighbors to keep an eye on it, or
Right.
you can buy something, for example, in a condominium unit, which is which has the gated entrance. So that would, because your neighbors are unlikely to squat in your home, it's probably going to be some kind of person who knows that this is going on, and he just can come in came comes in and then squats.
Yeah, yeah, makes sense. Well, we've covered a lot of questions, Larry, but let's finish on the one that's been manipulated quite often, and I wanted to hear your opinion on that. That's service animals.
Mm.
How do you define service animals? And because in my practice, I quite often would see the case where people would move into the unit, there's no dog, and then all of a sudden there is a dog, but they present you with the service animal letter, which could be received on the internet for about $20. So what's the definition of service animals? How do you deal with it? Is there a way for you to evict the person if they have an animal that was not supposed to be present at the property? How do you deal with that? Because it's LA, everybody loves dogs and cats more than their neighbors, and but not all of the landlords are okay with that. So how do you deal with the service animals?
Well, okay, so as far as I know, only dogs can be service animals, true service animals. There are also emotional support animals, and those could be snakes, alligators, depending on
How are
what.
they different?
Yeah.
How are they
Um,
different? Service
well,
animals and emotional
service
support animals.
animals, yeah. Well, service animals, they are basically, if you have some kind of disability,
Hmm.
and the service animal just walks with you, guides you through. For example, you have limited eyesight. The service animal, you wear some glasses, or and you have this white cane, and the dog would just guide you through the crowd or somewhere. So those are completely untouchable. You can go in. So if you have, for example, like a service dog, which must wear the proper vest. I forgot which authority certifies them, but they have to be certified, and they have to wear certain vest showing that this is a service animal. Pretty much you can go anywhere with that animal, and not doing that and prohibiting that risk an immediate lawsuit for disability. It's an ADA violation.
Hmm.
So if it's an emotional support animal.
Because I feel like they're all emotional support animals. I mean, what are the other purposes? Most of the, especially here in Los Angeles, those cute dogs, they're not protecting properties. They're all giving their owners some kind of emotional support. So what's the definition of emotional support animal?
Well, it's pretty much everything else. It's like every other animal is an emotional support animal. So those are completely legally, those are completely different. Those are not considered to be required for you to under the disability laws. And so
Hmm.
for example, if I have a pet snake, which I love snakes. I mean, I can't go, with a snake with my pet python in my favorite restaurant and just like, guys, look, this is my emotional support, this is my disability support, I have a disability without snake. No, you just can't do
Hmm.
that. You can do it with the dogs, and the dog has to be trained, certified. So those are different.
Hmm.
But having said that, there is, I believe, the law this year, there is a new law, state law, which is adopted, which actually forces the landlord to which limits the rights of landlords to refuse to rent to people with animals, no matter what kind of animals. Well, maybe I'm not sure about crocodiles, but I think dogs and cats definitely. So I need to read this law, but I think it doesn't matter if that's an emotional support animal, that's a disability, dog, an IC dog or anything else. I believe there is this new law, and it severely limits the rights of the landlord not to rent to the owners of cats or dogs.
That
So
sounds like California. Sounds like Los Angeles to me.
yeah,
And I mean, there's several laws that recently passed that limit the landlord's abilities to run the credit checks and to receive the deposits. And it's just another step in the direction of California being very, very tenant friendly state, which is not news and not a surprise. But I wanted to thank you for your time today. I mean, we've covered a lot of topics. I have about the same amount of topics that we haven't covered, but I don't think it would be fair for me to keep you here for 3 hours, because we've already been in for about an hour and a half. But
yeah.
I'll be honest with you, every time I have a chance to grab an attorney and to have a conversation, I try to do it simply because I truly believe that we need to educate our client prior to sending them to you or to any other professionals where they absolutely have to do it. Whenever the question arises, as pertains to landlord tenant laws or asset preservation or family law or anything like that, I always suggest that people just have a conversation with an attorney. And it could cost them a couple of $100, but being in a violation would cost them thousands of dollars. So 10, 100,000 times more than that. So I value an opportunity to talk to you, and you've been very, very helpful. I truly hope, because I'm doing this for the first time through Google Meet, so I can see that we're recording. So hopefully we will have a chance to have that recording and use it for our purposes. But wanted to say thank you very much. If we have a chance to post it, I will put your information, which I'm pretty sure you'll send me after our conversation. Put your information down below. But if somebody's watching right now, if somebody would be watching this video and would watch it to the very end, what's the best way for people to get a hold of you?
You can just email me at valery.polyakov@gmail.com. This is my first name dot my last name @gmail.com, or call me at 925-385-6968. 925-385-6968. Okay, yeah. So that's probably the best way of getting hold of me. Yeah, you can Google my name and you'll find me.
Well, thank you so much, Valery. I really appreciate you.
Yes.
Really appreciate you. It's been fun. It's been fun talking to you, and hopefully we can continue down the same path. Maybe next time get a little bit more specific about certain questions, because now we kind of covered very, very wide area of questions as it pertained to landlord-tenant relationships. Maybe next time when we'll have this conversation, we'll dive a little bit deeper into more specific parts of it. But for now, I just wanted to say thank you very much. You've been very, very informative, and I haven't seen the typical attorney talk that often. I've only heard answer "it depends" only a few times. Well, thank you so much. Thank you so much, Valery. I appreciate your time. I'll talk to you soon.
It was my pleasure. Thank you. Okay. Yeah. Bye-bye.